If a deceased loved one only has a bank account, do you need to file for probate? What about if the bank tells you you need to file for probate? Then what? Well, let's talk about it. If, let's say, a loved one, let's say a parent or a sibling or anyone in your family or even a friend, if they have no real property, which is the number one reason why probate would be needed, and let's say they only have a bank account and maybe some retirement or maybe some investments, and they have beneficiaries to those investment accounts, to that retirement account, but they have this bank account without beneficiaries. Bank account have what it's called payable on death designations. Please go to your bank and make sure you list someone who would have the authority to collect that money upon your death. Don't add them as a joint tenant. You can give them some limited powers if you want, but make sure that you have someone listed on your bank account where they can collect that money without having to go through probate, or to make it very easy to do so. So, if a loved one just passed away and they only have one bank account because they lived with a child, or maybe they lived in a retirement community, or for whatever reason they're renting, they don't have real property, but this account, and then what? If you go to the bank will likely say, look and see that there are no payable on death, and then they say you need to file for probate. Oklahoma law provides that if a person has financial accounts under $50,000, they may be collected with an affidavit of small estate, meaning that you won't have to go through probate. But if the bank account or the financial accounts are over $50,000, you would likely have to file for probate, meaning you'd have to go through the court system and administer the estate, pay debts, collect the assets, and then distribute whatever is left over. So this is very easy to avoid. Be sure to have beneficiaries on all your accounts and add payable on death on your bank accounts. It is worth mentioning that if your loved one only has a bank account and they also have a will that says, I give all my bank accounts to my son, that may not be enough to avoid probate. Usually a will has to be probated. A court has to declare that the will is valid and accepted to probate to administer the deceased person's estate. Also, if you go to the bank for a loved one and they say a probate is needed, even though you know with certainty that that account is, let's say, $8,000 or an amount under $50,000, be sure to ask if you can use an affidavit of small estate. They may refer you to an attorney, and be sure to consult with an attorney. Maybe you can avoid probate and use this legal process of an affidavit of small estate. I hope this video helped answer some questions. Please go to your bank and put payable on death beneficiaries on everything. Make sure you put beneficiaries on your other financial accounts, your investments, life insurance, pension, whatever you may have. And watch our other educational videos and see, especially if you have real property, what you can do to avoid probate. Subscribe to our YouTube channel so you can get notifications when new videos are posted. Thank you for watching.